When deciding custody, the Arizona judge is going to look to ARS 25-403. That is the statute that outlines the best interest factors for determining what is in the child's best interest, typically relating to parenting time or legal decision making. There are several factors in that list that the court's going to look at, things like the child's relationship with both families, how the child's doing in home and school, whether or not there was domestic violence in the relationship, whether one party has committed any acts of child abuse, of course, would be considered in that determination. But these are just a list of factors that the court is going to look at. There's not one that's more important than the others, but just a list of factors the court is going to consider whenever the court makes any legal decision making or parenting time decisions over a child. A parent's ability to co-parent is a huge factor in determining how the court is going to issue legal decision-making orders in your case. It's really important that parents try to work together for the best interests of their child, and occasionally you'll see one parent who perhaps is still not over their relationship. They're probably bad relationship with the other parent, and they can allow that to impact how they're going to make decisions over a child. When the court sees that type of situation, they're typically going to err on the side of giving legal decision-making abilities to the other parent who's able to make decisions that are in the best interest of the child, rather than the person who's stuck and fixated on that relationship and wanting to create controversy between the parties. Arizona does at some point consider a child's wishes in child custody determinations. It is one of the best interest factors. There is no bright line rule as to when we're going to allow a child's wants to be heard. Typically, we see it between the ages of 11 and 13. The court does have to weigh the maturity of a child and the child's actual ability to understand what's going on in determining at what age we're going to start to consider the wishes of the child. And I always tell clients, remember, the court's going to take your child's wishes with a grain of salt. Right? These are children. These are not adults. We don't allow them to make big decisions over themselves because they're not mentally mature enough to be able to do so. And so when a child, a 12-year-old for say, does say they want to live with their dad or their mom, perhaps maybe that's motivated by factors like their dad just bought them a new car or their boyfriend or girlfriend lives near dad's house. The court's really going to take those wishes with a grain of salt, and the court is still going to look to those other best interest factors to determine what's in a child's best interest for parenting time. Domestic violence is a huge factor in custody determinations. We see it play more into legal decision-making abilities. The court doesn't want to force a person who is abused to make legal decisions with their abuser, and because of that, we'll typically err on the side of when there is significant domestic violence, allowing that abused party to have sole legal decision-making or at least final decision-making authority. Domestic violence is a huge factor that we weigh into the best interests of a child. Substance abuse and mental health issues are a big factor in determining child custody. The court will look to 25-403, which outlines all the different pieces of evidence that the court can consider in determining whether or not there was a substance abuse issue with one of the parents. If they do find that there's a substance abuse issue, that parent will have a rehabilitation process to be able to get themselves back to the point of something like joint legal decision making or unsupervised parenting time. But these are really tricky. They're really important that you have an experienced attorney helping navigate that through with you.